Section 91, capital H, subsection 2 of the Crimes Act 1900 in New South Wales makes it an offence to produce, disseminate or possess child abuse material. The maximum penalty in the district court is 10 years imprisonment, and the maximum penalty if the case stays in the local court is 2 years imprisonment. The definition of child abuse material is contained in another video that we have. The definition of production is filming, photographing, drawing, or otherwise creating. It also includes entering any agreement to produce child abuse material. The definition of dissemination is distribution, supply, exhibition or transmission, or again, entering any agreement to do any of those things. The definition of possession is that the material was under your custody and control. So it can include where material is found on your computer or in your home. The defences to child abuse material charges are where you didn't know that the possessed or disseminated material was there. For example, if another person downloaded the material onto your computer, or where you accidentally downloaded it, or where after you realised that it was downloaded or there, that you took reasonable steps to get rid of the material. Another defence is where the material was produced for public benefit or law enforcement. Another is where it was produced for police work or for a scientific, medical or legal purpose. Also where the material was classified. For example, it was given an M, MA or R rating. Also where it was for approved research. And this means that it was produced or used solely for the purpose of scientific, medical or educational research that was approved in writing by the Attorney General. If you wish to plead guilty to a child abuse material charge, the court will take into account a whole range of factors before deciding what penalty to impose upon you. They will take into account a range of personal factors. For example, any prior convictions that you have, i.e. your character. Any evidence of remorse that you have, that is, whether you're sorry and you've shown that. Your age, any health or psychological problems that you may have, the effect upon your career, health and life generally, any efforts you've made towards rehabilitation and the likelihood that you will offend in the future. They will also take into account a range of factors associated with the incident itself. That is the level of planning, sophistication and skill involved in the offence, whether you acted alone or as a part of a network in conducting the offence, the number of persons that you transmitted the material to, if any, whether you received any payments or material benefits, the amount of child abuse material that you have, and the number of children that were depicted or affected, whether the material was for your own personal use or whether you intended to sell or distribute it, whether children were actually involved in the production of the material, the age of the children involved and the type of sexual activity portrayed. That is, the younger the children and the more explicit the material, the more serious the offence is deemed to be. The seriousness of any cruelty or physical suffering that was depicted, how much you contributed to the material's creation or existence, whether the material was at risk of being seen by other vulnerable people such as other children. The official sentencing statistics suggest that in the local court, 45% of people were sentenced to prison for the charge. 30% were given what's called a suspended sentence. And that is essentially a good behaviour bond, which if breached, means that you're likely to be sent to jail. In terms of the length of the prison sentence in the local court, the average full term of the sentence was 12 months, and the average non-parole period was 6 months. And the non-parole period is the time that you must spend in jail before you are eligible to be released from jail. The remaining penalties were a range of good behaviour bonds, community service orders, and what's called intensive correction orders. In the district court, 80% of people were sent to prison and 10% received a suspended sentence. In the district court, the average full term of the prison sentence was 2.5 years, and the average non-parole period was 12 months. If you wish to plead not guilty, a good lawyer will be able to fight for the withdrawal of the case on the basis of a lack of evidence. That is, that the prosecution cannot prove the offence beyond reasonable doubt. For example, that they cannot prove that the material was child abuse material, that it was offensive, or that they cannot prove that you, to the exclusion of others, produced, disseminated or possessed the material. It could have been somebody other than yourself. A good lawyer will also, in certain circumstances, be able to get the case dropped on the basis that you have an available defence. For example, you did not know that the material was there, or that you got rid of it after finding out that it was there. A good lawyer will be able to do this, that is, get a case dropped by sending what's called representations to the prosecution. And representations are a detailed letter which highlights the fact that they cannot prove the charge beyond reasonable doubt, and that there was a defence, and that they should therefore withdraw the case rather than spending the community's money in taking it all the way to a hearing or trial. Now, a lawyer should chase up those representations through what's called charge negotiations. That is, they should set a time when they speak with the prosecution and push for the withdrawal of the case. Now, if the matter goes all the way to a hearing or a jury trial, of course, a good lawyer will be able to fight to prove your innocence in court. If you wish to plead guilty, a lawyer should be able to reduce the number of the charges or to amend the plea's facts to show the charge as less serious. They should be able to refer you to counselling and obtain a letter from the counsellor which shows that you've taken steps towards rehabilitation and that you are sorry for the offence that you have undertaken. They should be able to assist with your character references, with any letter of apology that you may wish to do to the court, and they should be able to persuasively present your case in court so that you receive the minimum possible penalty.